Okay, so there's Claudia Hoerig on the stand breaking down, supposedly crying, showing a lot of emotion, or at least purported emotion. So, Paige, I mean, you got a lot of miles behind you, as I do in the trial world, and we all know that putting a defendant on the stand is very difficult. I don't see how they basically get to the defense in this case unless they put the defendant on the stand. How do you think she's faring so far as to try to mitigate? And what are your thoughts about whether, can you give us an idea of what your thoughts are about passion provocation, as we call it in most places, versus manslaughter?
All great questions. I certainly agree with you. I think a lot of the time in a murder case, your first instinct is do not put the defendant on the stand unless you absolutely have to establish some element of your defense. If the defense here is some sort of battered person syndrome, some sort of justification, self-defense, I think the jury has to hear from her in her own words what she was thinking at the time, what she was feeling at the time. That's the only way that defense stands a chance. But I don't think she's doing a good job here. In fact, it's kind of painful to listen to this. We would call this in Georgia a slow guilty plea. I mean, she's given a story. It's interesting, but I don't think she's establishing a defense here that would go to the actual elements of the crime. As you and I both know, you don't have to plan a murder weeks in advance to still be convicted of aggravated murder. It just requires an intent to commit the act at that time, absent some sort of provocation. And I have not heard or seen any evidence of provocation.
Yeah, and Paige, the prosecution did a pretty good job at showing all the effort she went to get this weapon, and she wasn't in a distressed state and was asking for even more firepower, things of this nature. Of course, she's saying she was going to use that in this quote-unquote suicide machine. And then in the end, she made a statement to the cops that it was either his life or mine, but not in your typical self-defense scenario, i.e., I would have either killed myself or it was him, because he had said to her, look, if you're going to shoot yourself, but don't get blood on the furniture, and she just snapped. So I want to talk to you about a legal principle. In Jersey, at least, passion provocation has to be reasonable provocation. You don't have an opportunity to deliberate or cool off. And in fact, you were provoked, and in fact, you did not cool off. And also, we say in Jersey, is it the same in Georgia? And I'm looking up in Ohio, mere words alone are never enough to justify a passion provocation. Same with you guys?
It is, unless, of course, those words are some sort of direct terroristic threat, like I'm going to kill you right now and I have the means to do so. Other than that, I mean, being a mean guy, saying I don't want to get your blood on my paintings, that's not provocation for a shooting. That's not a defense to murder.
Yeah, thank you, Paige, because I want the audience to understand that when, at the end of these cases, these judges read the law, and you may say passion, and then people get the idea like, oh, yeah, I'd be enraged too, but it's much, much more than that, that in order to avail yourself of that defense. Paige, excellent analysis. We got to go to a quick break. Stay tuned. Don't leave. We're going to come back with more Law and Crime. Okay, welcome back. It's a good time right now while they're taking a look at some photographs. Paige, I've had forensic anthropologists on the stand. I always find it to be fascinating because it's kind of like those archaeology shows that you watch on TV. She talks about how they go and approach the scene. They only go down 10 centimeters at a time, usually when they're going into the ground. But they find this skull, and she immediately identifies it as being the skull of a prepubescent person, i.e. a child. It turns out that that will be one of the children, sadly, that was murdered so brutally by a sledgehammer that was 3 pounds in weight nearby those sites. I find it to be, while there's not a mystery here so much, I think it's very compelling to a jury viscerally to listen to this testimony and see these photos again.
It certainly can be, and I'm sure that's what the prosecution is thinking. Let's walk through this evidence slowly. Let's try to put the jury on the scene as if they are making this discovery and seeing these bones for the first time. If you have a good expert, and she appears to be one, they can almost teach the jury about their particular field of study as they're walking through the evidence in the case. Some of it's going to be a little dry, but if you're focused on what really happened and trying to put yourself in the position of the people that were investigating the case, it's powerful testimony.
Right, and I'm a big believer in putting the jury in the place of the scene as many times as you can, because eventually a court's going to say you just can't keep doing it. But this allows the prosecution another shot at the apple. I got 10 seconds or less. Do you think that's a good tactic to keep bringing them back to that scene?
I think they're going to need to, but they've got a lot of problems in this case. Unlike the other one, I really think the evidence here is thin. I see a lot of reasonable doubt. We'll watch it play out over the next few weeks, but they've got a challenge ahead of themselves.
Right, because in this particular case, to your point, it's not so much that they were killed, it's who killed them, as opposed to the other case where that's admitted. We got to take a break. We're going to be right back. Okay, so there's the forensic anthropologist, Paige. What's big in this case, and I was trying to figure out where the prosecutor was going, but I like her questioning for the most part, but there's this DNA that was found there that does not match the victims and does not match the defendant. And interestingly enough, I want to go through some data points. She says she is not an expert in DNA, although has gone to a couple of lectures. The defense is objecting to her giving opinions about DNA. The judge will not let the defense lawyer make a record, which I think is a big mistake for the prosecution. Even though you may not like it, you want it on the record so that the judge can competently rule. And yet she's allowed to testify, not being an expert on DNA, that it would be impractical to figure that you could get DNA because of the conditions in the desert, the cross-contamination from plants and other animals. It's not practical to recover DNA. Yet, Paige, they did try to get DNA, so if it's not practical or what have you, then why do it? Certainly, if they have gotten a hit, they would have admitted it as evidence against the defendant in the case. I find it, I don't know, as a juror, I don't like that kind of testimony. Do you find that kind of wobbly?
It is wobbly, and frankly, I'm surprised the judge let it come in. She doesn't have any proven expertise in DNA analysis or DNA gathering techniques. I think that is something that should be left to a DNA expert. Now, I don't know what experts the defense has retained for this case. We know that there was some DNA found there, so obviously you can find DNA at the scene. The question is, does it support the prosecution's case? And the answer is no. So it is good strategy, though, for the prosecutor to try to get out as much as possible. Hey, no one expected to find DNA matching the murder at the scene. It was just not going to happen, too hard to do. So I applaud them for doing it, but you're right. I think that objection had merit. The judge should have heard them out. Maybe he's going to allow them to make a record once the jury is out. I don't know.
Yeah, I mean, I get the idea of getting out ahead of things as a prosecutor. God knows I did it in murder cases many times myself. But when you say it's impractical, when you have other witnesses that tried to do it that are, in fact, DNA and crime scene experts, it's one thing to say we couldn't get it, we couldn't match it. It's another thing to say it's impractical when your own people did it. I think you get nicked on your own credibility as a prosecutor when you do that. And I think that's important.
Yep. They're reaching too far, Bob, and that's exactly what they're doing in this case. And I think they're doing it because they know that the case is weak. They have some holes in it, and this is a very big hole. If the defense handles it the right way, if they have a good expert, or even just using the prosecution's witnesses and saying, look, you can find DNA evidence at a crime scene. You guys looked for DNA evidence at a crime scene. In fact, we found some DNA evidence. Yeah. It just doesn't match your theory, and so it wasn't helpful to you.
Yeah, Paige, as a defense lawyer, as skilled as you are, and I would hope that I would be half as skilled, I would have a half-day field day, perhaps, cross-examining this expert on the very points that you raise to really just nail I mean, it's not just that you're going to obliterate the testimony, you're going to take the prosecution's credibility along with you if you do it right. We'll wait and see about that, Paige. Excellent analysis. Thank you so much. We have to take a break. Stick with us. We'll come back with more of this fascinating case on the other end. Okay, we got a sidebar. Matt Mangino, I know you're here as well with Paige. Welcome to the show. Real quick, how you doing? All right, maybe not. Paige, let's go. I love the fire of this prosecutor. Maybe it's because it's me looking in the mirror a little bit there. But I'll tell you what, when he said you were gone for 10 years, 10 months, 5 days, I love his fire. He then said, but you saw your family, and she said no. And you married a husband for 11 years and had a house. She said no to the house. They lived in a shack. I was saying offline, that would have been, yeah, that's because you're trying to hide because you knew you murdered somebody. But he's doing good. What are your thoughts?
Better. You know, it is important to kind of draw her out, to let the jury hear from her, because I think the more the jury hears from her, the less they like her. So confront her on minor stuff. Let it be clear that she's living her own life while her ex-husband is dead. Certainly, you know, press on some of the key points she was trying to make, but don't try to overdo it. You know, you don't have to win this show. I don't think the jury is predisposed to believing her, so you can overdo it as a prosecutor here. You can beat up on her so much that the jury may shift and give her a little bit more favor.
Ah, come on. We got to give her a little more time to beat her up. Let's see. Let's go back to court. Thanks, Paige. Okay, Matt Mangino, I think you are still with me, my friend. Are you there? All right, Thiel, college adjunct professor with the Lutzenberg firm, syndicated columnist at Gatehouse Media, and the author of Executioner's Toll 2010 et al. Guys, I love having you on. All right, Matt, what's your point of view? I kind of like the sparky, in-your-face prosecution. In the chat room, there were one or two people said, why doesn't he calm down a little bit? It seemed like the rest of the folks liked it. I like it. I look at them like our juror. But I always said to my prosecutors, be yourself. What do you think of this guy so far?
Well, you know, I like that there's sort of a rhythm to what he's doing. He's working quickly. He's leading, which he is supposed to do, and he's getting yes or no answers out of her. You know, right now it doesn't seem to be overbearing, but where's it leading? You know, I want to see, you know, where this is ultimately going. When you have build up, you need a crescendo. What's it going to be?
Yeah, well, I'm going to be Mr. Homicide prosecutor myself. Give him a little time. He's only been in the arena with her for about 4 minutes, and she's already sparked off, kind of got nasty, shooting back at him, not making a good appearance, in my opinion. Matt and Paige, I'm expecting good things from this prosecutor down the road. Let's go back to court. All right. So, Paige, I'm going to go back to you, brother. I like it because I'm going to tell you why. He's passionate, but he's also bringing out his case through his questions, irrespective of how she answers. And as a prosecutor, too, you're taking the temperature of your defender, any cross-examination for that matter, even as a defense lawyer, and you know you're going to get under that person's skin. I think he's doing a good job both factually bringing his case out through this witness as well as showing her temper.
Factually, I agree with you. Clearly, he had this cross-examination mapped out. He knows the facts he needs to get into. You're right. He's trying to re-emphasize the strengths of his case through her testimony. But he has got to be careful. Remember, he needs that unanimous jury. And if one of those people in that box think this guy is overbearing, he's just over the top, he's too much, they may start to side with her. This is a rock-solid case for the prosecution. You don't want to make a fundamental mistake during the cross of the defendant.
Yeah, and I understand that, and I don't disagree with it, Matt, but it's also a point where you have to gate. This is the art form of cross-examination or any examination that people don't get or you can't get when you're in law school. You have to Paige's point, know when enough is enough. I don't think they're there right now, especially because she keeps sparring with him. But I do agree that you can beat a witness up where they start to become sympathetic. I just don't see that in her.
No, I don't either at this point. And I think, you know, what he's doing very effectively, too, is showing that she's kind of being a little petty about dates and things like that. That's not the issue here. I mean, he's asking about a gun. You purchased the gun. She's saying, I don't know if it was a Friday or Saturday. I think that's important for the jury to see that she's kind of making, you know, a mountain out of a molehill, trying to somehow distinguish between the days when it's about buying a gun that she used to shoot her husband.
Right, so I think we're all in agreement so far. We're on the same page, no pun intended here. So far it's effective, but it could go too far. Let's take a look at it on the other end of this break. Don't go anywhere. This is going to be hot. Okay, welcome back. Wow, this has been some show. Now, some may like it, some may not like it. And Paige, I know you got to go soon, so I'm going to throw it to you first. I got two questions for you. First, I liked at least, forget the demeanor of the prosecutor, the fact that he was like peppering questions with the centerpieces of his case. Before you shot him, you did this, and before you shot him, you did that, and before you shot him, you did the other thing. And then he keeps getting back to that shooting thing. He's bringing out each aspect of his case that shows it was a premeditated act as opposed to a passion prob. And then the last question is a substantive one I have for you. Did I hear her correctly, or the prosecutor say you walked down 10 or 12 steps, put the gun to his head, and pulled the trigger on the last shot? I thought it was the first shot that killed him.
Right. Factually, I think that was their position. That was the first shot. I mean, her testimony is all over the place. I think she is doing a horrible job. I feel very badly for these defense lawyers. I don't know if it was a lack of preparing her to testify, but she has not done herself any favors by testifying. Now, the state's cross-examination was fine. Technically, they got out the right points, but I think his demeanor was over the top. I mean, the judge had to sustain some objections, had to tell him to take back questions. You don't want to do that in front of the jury. And his comments about the miscarriage and the pregnancy, that's not going to go over well with the women on the jury. So I don't think that was necessarily a good strategy. But this case was over during her direct examination when she said she could not get a fair trial here in Ohio. I think once she said that, the jury's shut down now. We're just going through the motions from this point forward.
And Paige, knowing you got to go back to you one more time. 2 quick notes. First of all, on redirect examination, she started to kind of get sassy with her own lawyer and not be able to answer questions because she was so flustered. And on the point of whether the prosecutor went too far, I guess that's when we're sitting here watching this, it's one thing. But one of the chatters in the chat room said something I think is really important. We know this is trial lawyers. You have to kind of have an eye and look at the jury to see how they're receiving it.
Absolutely. I mean, Jerry Spence, I think, said one time, and I think this is great advice, you don't want to beat up on a witness until the jury wants you to beat up on that witness. And maybe he was feeling that in the courtroom. I don't know. I still think he could have made his points better without necessarily trying to beat her up too much. And as far as her redirect performance, it was awful. And again, I've been in that position where I've had a client who you had to put on the stand either for the defense or because the client was demanding it. And remember, it's always the client's choice. Defendant has an absolute right to testify whether the lawyer wants her to or not. So he's up there trying to do the best he can. He can't keep her locked into a story. He can't keep her consistent. It really is a train wreck for the defense at this point.
Paige, listen, I want to thank you so much. I think that one of the chatters said it best, SC lady out there, who called her testimony, the defendant's testimony, Hoerig, almost pitiful as we watch her right now. She's getting off the stand. Paige, thanks so much. Come back soon. Perfect time, guys, to take a break. If you have not been watching us, you have to stay because I'm so excited as a trial lawyer. I can't wait for the next piece. Let's go to break. We'll be right back. Okay, so we have the forensic anthropologist here. Matt, she had shown some photos, or the prosecutor had shown some photos previous to this. I'm interested in your point of view. And even though she indicated she's not qualified as an expert on DNA, they started getting into the discussion of crime scene contamination. Now, we know that they collected DNA, and we know that there was some DNA found on the wife's body. I believe it was on her clothing. That was of somebody who is yet to be identified, but certainly isn't the defendant. And she opined over the objection of the defense in the case that it was, quote, impractical to do a DNA analysis because of the desert and the cross-pollination, if you will, of plants and other materials. I found that to be really suspect, especially since the prosecutor made a point of saying that she's not really a DNA expert, one. And two, then why would they have even taken DNA that they found was human DNA? What are your thoughts?
Well, that is troubling, and especially, prosecutors don't want to try cases twice. So they want to, make sure that they don't get into areas where they may be prejudicial and an objection is raised and it could be an issue that could be brought up on appeal and you bring this case right back to try it again. So prosecutors, and I spent 8 years as a prosecutor, are often trying to ensure that there aren't prejudicial issues, there aren't appealable issues that come out, especially with your own witnesses. And that's troubling that it happened in this particular instance.
You bring up a very, very important point, Matt. When I train my trial prosecutors, or many prosecutors for that matter, have my career, especially vis-a-vis homicide cases, I would tell them you're not just trying it to a jury, you're trying it to the appellate division as well. And at a minimum, I know it sounds counterintuitive, but for those who are in law school that have watched the Law&Crime Network and many of the attorneys that watch us because of our great commentary from people like you want to protect the record. And the judge not allowing at least the defense to make the argument really opens up the door on appeal where they can argue anything at that point in time. I, as a prosecutor, would have seen myself saying, Judge, can we go to sidebar? Please let the defense lawyer put his objection on the record. And I always inured towards the idea, Matt, of, you know what, let it in rather than exclude it so it doesn't get reversed. And I never got reversed once in all my years as a prosecutor.
And I think that's a good approach, and that's the appropriate approach. And a good rule of thumb is you want to protect the record. You don't want to try this case again, and if you can prevent errors from occurring, you want to do that.
Yeah, and God knows, Matt, and the Law&Crime Network that handles these cases gavel to gavel, this year alone, 2018, we saw a number of retrials of cases. Prosecutors' cases don't get better, and sometimes you have to wonder, you know, you play by the rules because you want to get it right. You don't want to just win. It's about getting it right. We got to go to break, guys. You know we are on fire here today at this network. I'm going to calm down a little bit, powder myself, and we'll be back on the other end of the break. Okay, well, welcome back. We have heard extensive closing arguments. I think we got it. I've got, listen, first, hashtag Jersey Girl, Linda Kenny Bodden, who is going to be guesting with me just for a couple of minutes. She's been sitting here for the closing arguments, but we'll be back at 5 o'clock to host. Welcome, Linda.
Thank you, Bob. So, I know you want to ask a question.
Not yet, because I have another guest to bring on, Linda.
You want to ask two questions.
When you get to ask the question, you'll be sitting here very shortly, and you'll be able to run the show.
Jersey
but right
people.
now, I know, Jersey Pushy. It's Katie Cherkasky. Katie, how are you? Welcome. I'm very impressed with your credentials, Katie. It's the first time I believe we've been on. You're a court-martial defense attorney. That's pretty amazing. You were a prosecutor in the JAG. You started the U.S. Air Force when you were 18. You're part of the hashtag #MeToo movement, published nationally in the print and TV news, a specialist in sexual assault, common law, and military justice, Operations Iraq Freedom and Enduring Freedom, and going a little bit further back, from the Chapman Law School, summa cum laude, and the valedictorian. Katie, welcome.
That's right. Well, thank you.
All right, listen, you know, you've been patiently waiting, Katie, and since Linda's going to be hosting a little bit later on today, let me ask you, what did you think of the summations? And in particular, I want to start with the prosecution. I believe that the cross-examination of the prosecutor of the defendant was pretty spot on. He knew exactly where he was going. He drew blood. She was kind of combative with him. I think that it was a fair fight there. Do you think that he did as effectively in summation?
I do. I think that the defense's attempt to portray her in a sympathetic way really fell flat, and I think that the prosecution really honed in on that on the cross. The history of abuse and everything that they were trying to get into is an interesting theory, but I just don't think it's going to get the defense to where they needed to go.
Right, and Linda, to me, the facts kind of get in the way. Now, we were talking about the prosecutor's done an excellent job.
Right.
So do not get me wrong when I say it. But I would have, I mean, and again, we could sit here. We've been in the heat of the courtroom, so it's easy to say. But I love that piece he got to, and it's okay. You don't have to get to it sooner than later. Everybody has a different style. About 2 days before she's out there, she's getting the gun, she's target practicing, the laser grips on the weapon, the shot to the head, the whole convoluted nature of the plan A versus plan B, and all the time she had to get away from actually having to shoot him. I thought the overall prosecution case was very effectively put in.
I think that the prosecution case was great. As a matter of fact, I wrote you a little rhyme sort of about how hot that temperature was in the courtroom. It was hot Fahrenheit, right? Because the sight, that's the laser sight, plus the flight, because we have the flight, is the prosecutor's delight, and you know that, right? It's absolutely, and that jury's going to expedite that verdict. You know that.
I love the lyric. If you could only lay it down to some music and actually sing it,
I have to have you there, Bob. I have to have you there.
That really would be unbelievable.
But it's true.
You are so
Lifeless light.
multi-talented. Katie, on the defense side of it, I would have liked to have listened to, and you're a person that's done, you know, been on both sides of the aisle here, a little bit more about the impassioned nature of things, because they're trying to reduce this offense from the most serious offense to a lesser offense, typically in most jurisdictions what we call passion provocation, which minimizes it from a murder to a lesser offense like manslaughter. But I just wasn't getting the feeling during the defense closing that was coming out. How about you? What do you think?
I totally agree. I think that the defense counsel tried to get into it a little bit, talking about the comment that was allegedly made, which is understandably hurtful, but I don't think it quite rose to that level. And he certainly didn't get into enough to overcome a lot of the prosecution's evidence of the prior calculation and design. He didn't explain that, at least not yet. So I don't see how we get from this alleged suicide attempt to the ultimate murder with the provocation. There just wasn't enough explanation of that, and the defense was kind of all over the place in different theories, but didn't spend enough time on that, at least not yet.
All right, well, Katie and Linda, our chatters are like our jury. Trial Nut said, when I said guilty or not guilty, way guilty. Rob Holland said guilty 1,000%. Tuna Pet said guilty and crazy. And so I don't think there was one not guilty there. I'm going to ask you real quick. We only have 10 seconds. Guilty or not guilty, Linda?
Guilty.
How about you, Katie?
Guilty.
All right. I think guilty, too. We got to take a break. We'll be right back. I'm signing off. Linda will be there at 5 o'clock.